In interpretation of statutes, the doctrine of pith and substance is a very crucial subject, crucial aspect. What is the actual meaning of pith and substance? What is the analysis of pith and substance, and what is the effect of it in doing justice? We shall be observing here in this video. So, the doctrine of pith and substance will be observed while deciding the validity of the enacted laws. The laws will be made enacted by both state government and also the central government. They have their own jurisdiction. Okay, before studying that, let's have the meaning of the pith and substance. What is the meaning of pith? It means essence of the law. What is the main point, core point in that particular law? Substance means the key aspect, the crucial thing, the most important part that is constituted in that particular law, and its effect also at the same time, whether it is made with good intention or not, whether the intention is very good or not, or any nefarious design, that will be observed while the court makes analysis of pith and substance. Here we have to know first to study about the distribution of powers between the state and the center. State will have the powers in that state list. See, the constitution has provided the distribution of powers. In the state list, the state will have to make laws. In the same way, in the central list, it has to make laws. And apart from that, there is another list, that is concurrent list. Both state and center can make laws from that subject, from the subjects that are mentioned in the concurrent list, that we know very well. So that is the distribution of powers. If they follow the principles systematically, scrupulously, means that they are following within the competence, within their jurisdiction, and the laws will be valid. Intrawires, no ultrawires. Suppose they have any contradiction. Contradiction means suppose the state will interfere in the central government list, or the central government will interfere in the state list. So there is a contradiction. There is a contradiction, a conflict of law. Then what will happen? If they go beyond their competence or beyond their jurisdiction, then the court will interfere. It is the turn of the judiciary to study it and make clarification. Then the court will apply this doctrine of pith and substance. While they are applying the doctrine of pith and substance, suppose the contradiction, the law made by the state government is contrary to the rules and regulations as laid down by the constitution, then the court make analysis. While analyzing the case, it will observe whether there is what is the actual objective of that law, what is the scope of the law, what is the effect of that law, or in other words we can say whether the law has any power of legislation. Whether state government, suppose the state government has enacted one law, whether it has followed its own jurisdiction, that is power of legislation, whether it has that. The second one is the field of legislation. What is the subject matter of that legislation, whether it's correct or not, appropriate or not. And the last important one is, actually this is the first one, but I am saying again, the most important one is third one, for example, the intention. What is the actual intention, purpose of that legislation, whether it is nefarious or aimed at something good. If it is nefarious, ultra-wise, the law becomes invalid. Ultra-wise, it is declared as ultra-wise, we can say. Generally, the state government or the central government will be following their own jurisdiction. They don't have any encroachment upon the other field. Sometimes, here and there, like a bottleneck, a sort of bottleneck, or some defective provision may be included, inserted. Then this doctrine of substance, the pith and substance, will be applied. Let's have some 2 or 3 cases. State of Bombay versus FN Balsara, one case. In that case, the state government framed one legislation, that is Prohibition Act, enacted by Maharashtra state government. But there, the sales, the position, what is everything will be carried out. But actually, the export, it will come under export and import customs of the original subject matter of this central government. But here, what has happened is, though the import, export and import, particularly import, was seriously affected, yet the court has decided in a positive way, because the entry 9, sorry, 8 of the state list, it is included. So the state has followed the systems, the rule, the entry number 8 of the state list very systematically, scrupulously. So there is nothing wrong. It is valid. It has its own validity. The judiciary said. And in the second case, that is a most popular case, that is Prafulla Kumar Mukherjee versus a Bank of Commerce, Kolna, 1947. In this case, money lending case, money lending act. In that act, the central government has been observing different provisions, and the state government has followed according to the act. And actually, it is in the state central government provision. But the court said no, the money lending will come under the state subject. It is beneficial. The intention is good here, the beneficial one, and not contrary to the actual original law. There is a good purpose in it. The money lending will come under this state list. So it has its validity, it's set. So the long and short of the matter here is that whether there is within the jurisdiction and competence or not, if at all any bottleneck on the part of a bottleneck found in the law, if the intention on the whole, that is called the effect. What is the effect on the whole? If the intention is good, even if there is a defective provision, if the intention is good, legislative intention, then it will become a valid. The law will have the validity. That is to be observed. The intention of the legislature is an underlined point, though there is some bottleneck here and there, or bottleneck as to the provision. And that is the reason why one great Justice Sandel, in his very famous book entitled Justice, in that book he wrote like this: when justice will be done, justice will be done, carried out, only when there is maximizing welfare, means welfare of the people, society, and respecting the freedom of federalism. That means both state and center must respect each other. The third one is promoting virtues. That means good intention, something good to the society, something right to be observed. So, welfare, freedom, and federalism, respecting federalism. And the third one is virtue. These ought to be observed well. So the doctrine of the pith and substance will be observing these three things while deciding a case, while deciding the validity of the case also at the same time. This is about the pith and substance in brief. Thank you very much.